which the suits were instituted, and she has 10 days to file her preliminary response. What becomes of those suits?
Well, thank you for your question. I think they have become moot. The Supreme Court does not exist, or any other court does not exist to give deal in academic matters. So if the real life issues were that the procedure had been truncated and had not been properly followed, and as usual, the press had interviewed so many lawyers who have brought in their perspective, and the president appears to have listened to those perspectives and therefore rectified what it was that was looking that bad, and for what people were rushing to court has now been rectified. If you say that indeed the issues, the petitions ought to be referred to you for your inputs before the prima facie determination, that has now been done. So clearly, I believe that those cases have become moot.
Right. Is it, from what you have heard from the presidency, is it really a matter of the presidency now listening and forwarding the petitions, or it is a case of, a premature preemption on the part of both the plaintiffs in the suit and the Chief Justice, the Honorable Lady Chief Justice, who wrote to the presidency on the 27th asking for copies of these petitions?
Well, the Constitution guarantees the freedom of speech, and as you know, the press or the media exercise that freedom when these things appeared in the media. Yesterday, I was on one of your platforms, and I was saying that were those involved flying kites? Because they set up a panel for all of us, and we also who was going to be chairman, so and so and so. Again, even reading the law, they are not members of the committee. So what was all this? And the Chief Justice, I think, was right in saying that she has also read from the media the things that are going on. And if the thing concerns her, then she cannot keep mute. So I think the media somehow created the brouhaha by saying that the committee has already been set up and they are about to embark on the preliminary investigations.
I'm not sure there was any report about a committee being set up. The presidency's communication was that the president had forwarded the petitions to the Council of State for consultation, pursuant to Article 146, Clause 6, which commands the president to consult with the Council of State in determining, not really in determining, okay, let's say because of a J-Chum, to determine a prima facie before the committee will be set up. So therein comes the question that they wrote to the Council of State on the 24th. And the Council of State wrote back consenting to the president. They wrote to the Council of State actually asking and seeking consent that they were to commence the process. And if the Council of State would approve, they would forward the processes to the Chief Justice. The very day the Chief Justice wrote is the very day we are told that the Council of State wrote back giving the consent. And then the next day, it is forwarded to the Chief Justice.
Samson, I'm aware, you are very, very much aware about fake news. I think it's been one of your takes before. So I believe there was a lot of fake news all over the place about the committee having been set up with the former Chief Justice of Akufu, Betimo, all kinds of names. And these were flying all over the place.
So Akufu is member of the Council of State. Betimo Idrisu is member of the Council of State. They are disqualified from being members.
I'm saying so. And yet these news items were all over the place. The committee, a 5-member committee has been set up with herself and the Betimo, people who are even supposed to be members of the Council of State. So I am not surprised. I mean, were you not in this country when we heard that Senator Rawlings had already been given a post, only for Fati to come out to say that nothing of the sort exists. Okay. And they were all on government letterhead, Office of the President, announcing appointments. They turned out not to be true.
Okay.
You get my drift. So I think fake news fed into everything, and then it made people to become a little jittery about it.
The president said he was.
It was.
The president said he was disappointed in the Chief Justice for publicizing her letter to, the council and to him and the council, and also copying, persons or entities who were not supposed to be part of this in-camera process. The law says the process, all proceedings must be in camera. So if you copy people who are not part of this process, you are rather, breaching the in-camera rule. What do you say?
Well, she was only asking for copies of the petition to be given to him. What I understand the law to be saying is that the petition should never come into the public domain, because people respect the judiciary, and if you scandalize the judiciary on points which are not true, only for them to turn out to be untrue indeed, then people might have formed impressions about the judiciary already. So do not publish the petition. I don't think that was what she was doing. She was only asking that copies be sent to her.
All right. So this debate about prima facie, is the CJ entitled to a prima facie determination, entitled to be asked to bring a comment or response for the prima facie determination? And when should that actually happen?
Well, if you have not heard the view of the person you are going to investigate, what kind of investigations are you going to set up for yourself? It's only fair that you hear from both sides and then try to find out where is the prima facie case. I mean, perhaps the person who is filing this petition may not have insights into the allegations that is making against the Chief Justice that maybe is authorized by the Constitution or by any other law to act in a certain manner. And then he believes that the act itself amounts to a stated misbehavior or something. Again, the rules are quite clear that the justice of the Superior Court or a chairman of the regional shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. This is the golden rule. This is the standard that you are to follow. So whatever it is that somebody is saying, let me also find out whether in fact he has brought evidence to show that I have misbehaved in a certain manner, I'm incompetent in a certain manner, or although I'm fit, well, and kicking, I'm still not that well as a result of infirmity of body or mind. So if you don't show these things to me for me to respond, how would you then make a determination that the prima facie case has been made against me? And it's not only that, but the Ajetu and the Tiger Eye Dairy cases all point to saying the same thing. It's only fair. I mean, it's like saying common sense arising from natural justice that you're going to make a decision against somebody. That person is entitled to be heard. And just show me the petition. Let me see what the people are saying. Let me respond to them. That when I did this because I'm authorized by law as the head of the judiciary to take a certain step. And that is all I did in accordance with the Constitution. It's like saying we should not empanel the panel that will hear the matter because you are interested. And the law is that whether you are interested or not, it is your duty imposed on you by the Constitution to perform that duty. So you must. So those who have made the petition against it, what are the grounds for which they have made the decision? And if she has a say, a defense to show that in fact she has not indulged in any of the things they are talking about.